you, Sadeq, and others.
Morning, my lords. Can I just come back briefly on something I said yesterday? I was asked by my Lord Justice Popplewell whether we accept that if you were against me on the first question of whether the iniquities are made out to the relevant standard, it would follow from that alone that there would need to be a re-review by Enyo, since in those circumstances their conclusion on that question would have been wrong, save obviously in relation to the concession relating to Al-Barat, and I said I did accept that. I just want to be very clear, my Lord, about what it is that I was accepting, so there isn't any doubt about that. As you know, we say there are two stages that need to be overcome to the relevant standard. First, the iniquities themselves, and second, that there are likely to be documents in further of or part of those iniquities, and as we understand it, that's accepted. And obviously on our case, even if they pass the first threshold, they fail at the second, such that the challenge fails, and there is no basis for requiring us to disclose particular categories of document, however those are defined. There is a separate practical question, my Lord, about whether, if you were against us on the first, but they'd failed on the second, we should, as it were, just go and look again on the premise that my Lords had found that the iniquities were made out to the relevant standard, and in light of anything you said about the test or the furtherance of the test, but on this hypothesis not having concluded the second threshold had been met. And in that situation, we would probably in any event, my solicitors would probably in any event want to do the exercise to satisfy themselves in light of what you found. So that was what I hope was clear. I think that's what my Lord was asking, but if I've misunderstood that.
Well, it wasn't quite. What I was really asking was whether, if the correct interpretation is, as I think you confirmed, that the conclusion that there were no documents to which the invasion of privilege applied was based on the fact that there were no iniquities established to the relevant standard, whether you accepted that it inevitably meant that if we took a different view on the existence of the question, you should be ordered to redo the exercise in accordance with whatever we decide the appropriate test is for the relationship question, even if that is exactly as you contend it should be. I think that, to be fair, that was what I was putting to you.
My Lord, that's what I understood, and that's what I have accepted, and we're at one. But that is different from the challenge as made, which is that specific categories of documents are not privileged and therefore have to be disclosed. Obviously, if they've established that, then there'll be an order relating to whatever the categories are. But us doing a re-review in light of the court's determination on the iniquities is a different matter.
All right. So, do I understand? It really depends upon whether does it come to this? You say, unless Ms. Oppenheimer can show that on the hypothesis we're talking about, there is likely to be at least one document that needs to be disclosed. You shouldn't be ordered to disclose. You should simply be ordered to review. But if you accept we were satisfied that on the hypothesis we're talking about, we think it's likely that there will be documents that are caught, would you accept that then you should be ordered to disclose? There should be an order, essentially, which orders you to disclose those which fall within the definition that the court determines.
The premise then is, and I'm sorry if I'm being obtuse, but the premise then is that they've succeeded at both stages. Obviously, if they've succeeded at both stages,
sorry, that's not my premise. My premise is they succeed on the existence question. Existence of an iniquity question. Whatever the result on the relationship question, and even if you are right on that aspect of the appeal fails, if the court took the view that because review team never got past stage 1, that if it had, applying your relationship question, there is, never mind possibility, likely to, whatever, but there may well be documents which would be caught applying your version of the relationship test. Do you accept then we should make an order for
Yes.
such documents to be disclosed?
Yes. In a sense then, my lord, I've lost at the second stage, but not necessarily for the reasons that have been given.
No, you haven't lost at the second stage at all.
Well, the court will have concluded that it is likely that there are documents that were in furtherance of the iniquities that you will have found. That's the premise I think my lord just put. And on that premise, we will have to disclose those documents. We'll have to check that they exist, but if you found that they're likely to exist, an order telling us that we must go and disclose them if your view that they're likely to exist proves to be right, must be right, must not.
Even if you're entirely right on ground 1 of the appeal otherwise than on the existing.
Even if we've got the right test, and you conclude that applying the right test, there must be relevant documents to disclose. Of course.
Thank you. Thank you.
My lords, can I then turn to the first iniquity, which is unlawful detention in Dubai, and then subsequently in the 4 different places in Ras Al Khaimah, and I'm going to disaggregate the points essentially into first the alleged illegal, unlawful detention in Dubai, and then secondly the alleged unlawful detention in each of the 4 places. So starting with the apprehension in Dubai, that is said to be unlawful because it is said to have been done without a request for extradition having been made by Ras Al Khaimah to Dubai. And just for your note, the reference to that is Mr. Siatalu's 6th witness statement, paragraph 71.6a, and that is in the supplementary bundle at page 46. Now, essentially, the entire basis on which it is alleged that there is a strong, prima facie, very strong, whatever the relevant test is, case that there was no such request, and therefore that what happened was unlawful, is that none of the parties has seen a copy of the request that was, if it was, made by the Ras Al Khaimah authorities. And in particular, it is said that Mr. Al-Haddad, who is Mr. Sadeq's local lawyer, who has given some written evidence in reply below about this, to the effect that he would have expected to see it on a file that he has looked at. Now, it is common ground that a request was, on the face of the relevant 1973 law, supposed to be made before any such detention in Dubai on behalf of one of the other Emirates. And so what is said is that since that request hasn't been seen, it must follow, or to the relevant standard at least, that it doesn't exist. We say that is a non sequitur. First and most obviously, the fact that any request has not yet been cited does not mean that it does not, or at least did not, exist. In particular, we say there's no reason why we would have seen it. We don't accept there's any reason why Mr. Sadeq would have seen it. And for our part, given we had no involvement whatsoever in the initial detention of Mr. Sadeq, and indeed knew nothing about it until after the event, it's entirely unsurprising that we didn't haven't seen it. And although Mr. Al-Haddad says he would have expected to see reference to it in a file that he has seen, the relevant file is one which it is the appellant's own case through Mr. Siatalu appears to be incomplete. And just give you the reference to that, that's Mr. Siatalu's 9th statement, paragraph 40.1, and that's at page 193 of the supplementary bundle.
Does the evidence not show, as one might expect, that if you're the subject of what is in effect an extradition request from one state to another, you would be served, you, the subject of the request, would be served with a copy of the request? That's what I can't quite remember how extradition proceedings work here, but as on ordinary rule of law principles, one would expect that to be the case.
I'm not sure there is any evidence to that effect, my lord. Of course, no.
Okay.
And would you expect the arrest to take place by the receiving companies' authorities.
I'm coming to that, my lord. Mr. Al-Haddad's evidence about what he says he would have expected to see is, we say, with respect, vague, unexplained, and is obviously untested. Moreover, is evidence that we haven't even had the opportunity to respond to properly, because it was put in at first instance by way of reply evidence. Second, and coming back to a point I touched on yesterday.
How long before the hearing?
I need to check that. Second, and coming back to a point I touched on yesterday, it would, we say, in fact, be surprising for the RAC authorities not to have gone through the relevant procedure and instead to have risked a diplomatic incident by undertaking, on Mr. Sadeq's case, some covert, unlawful operation in another emirate's jurisdiction. Third, and this is the point my lords has just touched on, the respondent's belief was and remains that Mr. Sadeq was not initially detained by the RAC authorities in Dubai, but by the Dubai authorities. And I'm afraid in that respect, my learned friend Skelton argument of paragraph 32.1 is just wrong to suggest otherwise. They there suggest that it's common ground that Mr. Sadeq was detained in Dubai by the RAC authorities. And that is based upon a misreading of our pleading, and in particular of paragraph 13.4 of our defence, which has been taken out of context and relates only to the subsequent detention in Ras Al Khaimah by the Ras Al Khaimah authorities. If I can just show you that, it's in the supplementary bundle. And it's at tab 12. I know my lords have asked for, and I have been provided with copies of the pleadings. These points, though, are in the supplementary bundle. I'm going to refer to them there, if I may. And paragraph 13.4 is the paragraph.
Sorry, tab 12, did you say?
Tab 12, paragraph 12, page 248, paragraph 13.4 is the paragraph to which they refer, which is just part of a summary of our case, where we say in September 2014, the claimant, the former general, was detained by the RAC authorities. That, as part of the summary, is then what is said to be the basis of the common ground, that is who detained him in Dubai. But, my lords, if you go on to page 252.
Sorry, just one moment. Yes, thank you.
Page 252, paragraph 46.1, actually addressing the allegations relating to the original detention in Dubai. We admit that on or around 5th September, the claimant was detained in Dubai. The defendants have no direct knowledge, but it's understood that it was carried out legally. Then if you go over, or to the bottom of the page, as to the relevant paragraphs, the defendants understood and still understand that, over the page, the claimant was apprehended by the Dubai police prior to being detained.
Sorry, so sorry.
Paragraph. Start to the bottom of 252, my lord. 40 paragraph.
Yes, I see. Thank you. Yeah.
So, my lord, our understanding was that it was.
Is there any source given for that understanding? In the evidence.
On instruction, my lord, that is their evidence of the defendants understand. That is the evidence of the individuals referred to at paragraph 46.1.
Yes, but nothing in the evidence which identifies from where those individuals got their understanding.
No, my lord, I think that was their understanding.
According to Mr. Seattle, there was, at any rate, one RAK state security person who identified himself.
Yes.
Although we don't know from him who else was there.
I don't accept if it's suggested that that means, if that is what happened, that makes anything unlawful.
Simply on the question of who carried out the arrest, that there was at least one RAK person there.
It doesn't follow that the arrest wasn't made by the Dubai authorities.
Well, I think Mr. Sadeq in his pleading, the truth is more specific and says when he was grabbed from the car, the person who grabbed him identified himself as a representative of the Iraq intelligence services.
I accept that that's what he says, my lord.
That's his evidence anyway.
That's his evidence, exactly. And that is not my client's belief as to what happened. The point I'm making is it is not common ground that that is what happened. At the very least, I could make that point.
Yeah.
We do not accept that, and for the reasons I've already given, we don't accept that is likely to be true. We say the more likely inference is that this was done between two emirates who have no reason not to cooperate in the way in which it should have been done. My lords, if, as was our understanding, the Dubai police were the people who did the detaining, it makes it likely, if not obvious, that there was the relevant request, because no one's suggesting the Dubai authorities did this off their own bat. There would have been a request by Ras Al Khaimah, as you would expect. That's the, as it were, lifting in Dubai. As for the subsequent detention in Ras Al Khaimah, in the 4 different places, and just to emphasise, my lords, this is not about conditions. This is about alleged unlawfulness on some other basis. And the short point is that there really is no evidence that these 4 periods of detention were unlawful on some other basis. In particular, the evidence in Mr. Seattle's 6th witness statement, paragraphs 71 to 73, which deal with this topic, focus almost entirely on the initial detention in Dubai, save that something is also said about the 5 or 6 days after that at GCHQ, out of the 26 spent at GCHQ, where it is said that he ought to have been presented to the prosecutor sooner than he was. We don't admit that that is even legally right, and there is certainly no evidence, certainly no sufficient evidence before you, that even if it's true that he should have been presented earlier, it renders his detention during those 5 days, or 6 days, unlawful, still less that anything thereafter was unlawful in terms of his detention.
You say you don't accept it's legally right, but the legal basis for it is clearly set out. Is there any evidence of local law to the contrary?
My lord, there's no evidence of local law to the contrary. But there isn't any evidence either that it means that the detention during those 5 days was unlawful. And there is no evidence either that any part of the detention thereafter was unlawful. As I say, we're not on conditions now. We're talking about whether the detention itself in each of the places was unlawful, and we don't.
If you were, contrary to your first submission, unlawfully arrested in another country and extradited, wouldn't that, at least prima facie, render your subsequent detention unless and until regularised in some way, ipso facto unlawful?
Well, my lord, I don't accept that it would necessarily do so. And built in is the question about when it was regularised, if the starting premise is otherwise right. And on any view, once we say he has been presented to the prosecutor and told what the offences are, we say that there would be nothing thereafter unlawful. And tested it, as I did yesterday, and forgive me, at the far end of it, following conviction, detention in the central prison, pursuant to a court order made by the court that had convicted him, we say obviously couldn't be unlawful.
You say obviously. If someone is subject to rendition, to use the popular expression, self-evident to me that if they're then convicted by wherever they're rendered to, the detention thereafter is lawful.
I don't need to fight with my lord on whether it's self-evident that I'm wrong. They need to show you that to the relevant standard.
No, you were telling me it was obviously right.
Well, my lord says it's not obviously right, and if it's not obviously right to my lord, it's not obviously right to everybody. But once a conviction, we would say, has been handed down by the court in the relevant country or the emirate, we would say that the sentence served pursuant to it is lawful. My lord, that's all I wanted to say about those, as it were, 5 iniquities comprising the first iniquity. That brings me to the second alleged iniquity, which is the conditions in each of the 4 places where it is alleged that they breached his rights. And if I can just run through the points briefly that are relied upon. First, the appellant relies on the NGO reports of alleged instances of human rights abuses in the UAE generally, and in a few cases in Iraq, Ras Al Khaimah specifically. We say those go nowhere, or certainly nowhere sufficient, even taken at face value, and ignoring the hearsay nature of such reports and the politics that often lie behind them. Evidence, if it be that X was subjected to inhumane conditions in the particular circumstances of his case at another time and in other circumstances, is evidence of that and no more. It is not evidence upon which this court can rely comfortably, safely, that the conditions in which someone else was detained were of that ilk. Second, Mr. Sadeq relies on his own contemporaneous letters referring to the conditions in which he say he was kept, but we say they do no more than show that some of what he alleges now he also alleged then, all of which, subject to the one point my lords know about Mitchell, is in issue and will need to be tested at trial. Third, he relies on the document referred to in Mr. Seattle's sixth witness statement at paragraph 66.2, and the relevant document is at F, the further evidence bundle, at tab 3, page 235. As you can see from the date, though, that is July 2014, and it is not, it's therefore several months prior to Mr. Sadeq's arrest. Therefore, this document is necessarily nothing to do with Mr. Sadeq. It contains allegations from a source about the treatment of unknown other individuals in the palace. That has nothing to do with whatever happened elsewhere, and whatever happened elsewhere to Mr. Sadeq. The fourth thing that's relied upon is Mr. Sadeq's pleaded case, which is summarised by Mr. Seattle in his sixth witness statement of paragraph 79 to 80, and the page reference is 49 to 52. Even on the face of that summary, you will see that virtually nothing is said about the alleged conditions in the villa, the central prison. But again, those are mere allegations which are not admitted and will fall to be tested at trial. We say are insufficient to discharge the burden on Mr. Sadeq on this case, given which on this case is the very strong prima facie standard. The fifth thing that Mr. Sadeq relies upon is a number of documents disclosed by us, and it's helpful if I can just ask my lords to turn this up. It's in the skeleton argument, the skeleton argument, paragraph 33.2, which is at page 42, starts at page 42 of the bundle.
So sorry.
Yes, no, it's the core bundle.
Yep.
It's the appellant skeleton argument, page 42.
Thank you.
And that paragraph 33.2. There, a number of documents are relied upon, and my lords can scan those. That paragraph. All of this, as you know, is then amplified in the other document that's been provided to the court. But these remain the essence of the points. My lords, we don't accept that other than for the Mitchell documents, which you see referred to at 5 and 6, that these are evidence of human rights, are sufficient evidence of human rights abuses. References, for example, to Mr. Sadeq having come in blindfolded or in shackles when arriving in a meeting is not, we say, such evidence. They were removed. Our cases and our evidence is that they were removed at the start of the relevant meetings and that those weren't repeated. The only documents in there which we accept, obviously, are the Mitchell documents. Dr. Mitchell was, as you know,
the sting, or part of any rate of the sting of the blindfold, that it was punitive. That he had been told that he would, in practice, not be blindfolded if there was full and frank cooperation. Isn't that what the allegation is?
That's at the top of the page.
Well, that's actually. I see. Yes, I saw.
That's alleged.
Yes.
I mean, that's the implication, that the inference that's drawn.
Yes.
We don't accept that that's
Yes,
a
I see. Okay.
fair reading. We don't accept that the blindfold is necessarily a breach of human rights, and we don't accept that what was being said was, put it this way, what we say is the implication of that is that things were going to be made better for Mr. Sadeq than they would normally be for any other prisoner in Ras Al Khaimah if the more he cooperated. And that's, we say, perfectly normal approach. My lords, the Dr. Mitchell documents we do accept, obviously show, say what they say, and on that basis we've accepted that the relevant standard, there is a strong, very strong prima facie case that the conditions at Al-Bararat around the time of the inspection were Article 3 non-compliant.
Around the time of the inspection? Can you just remind me what Mr. Allen says? Where does he deal with it?
Mr. Allen deals with this in his ninth witness statement, which is in the supplementary bundle at tab 7. Page 137, he starts dealing with the Dr. Mitchell report, starting at paragraph 71.
I was just trying to pin down what he said was treated by the team as the scope of the accepted.
I think what he says is that they're not in a position to challenge Mr. Dr. Mitchell's findings.
Yes, but what did they say?
I'm just looking for where.
He then says somewhere that evidence didn't lead to the disclosure of any documents, but if that was
Yes.
treated as being only evidence as to what the conditions were on the 29th, possibly close to the 29th, that itself raises an issue of whether that's a proper treatment as to the inferences that can be drawn from the evidence. I just wanted to pin down, but you said a moment ago.
I don't think he says
in the period around the
74.1. I'm not sure, to be fair, that that's his language. 74.1 on page 139 is, I think, the limit of the exceptions in Mr. Allen's evidence.
Well, he does deal somewhere, doesn't he, with saying that they then said there weren't any documents relating to that iniquity.
Can I get someone behind
Yes.
who finds that?
Yes.
My lord, what's your have in mind? And I'll come back to you.
But obviously, the point that I'd like your help on is whether it would be right for the team to have concluded that if what Dr. Mitchell said was strong prima facie evidence of iniquity in the conditions that he was being held in at the time of his visit, it was legitimate to conclude that it didn't provide strong prima facie evidence as to the conditions in which he was being held at the same facility
Earlier.
earlier.
I understand that, my lord, and I'll find behind.
Well, I'm confident.
You're putting the point to
I'm putting the point to you, not necessarily in by reference to what Mr. Allen says, because my impression is that it was either on the day or within a matter of days. But clearly, the conclusion was that it was a limited exception. And the point I'm putting to you is why would that be a justifiable conclusion?
My lord, I accept that if the conclusion was it was evidence only of it right at that moment or in a couple of days prior to it, that wouldn't have been the right approach.
But what about 6 months earlier?
Well,
What would be the basis for drawing a conclusion that conditions had deteriorated? It was likely, the evidential test, that he'd been held in humane conditions earlier, which had become inhumane.
my lord, I accept that one would have to conclude, absent some reason to suppose that the conditions had changed adversely, something on the documents to suggest that it would follow that those likely to have been the conditions of the period if its attention had done that.
You said yesterday that, page 121, everything that described the conditions in which Mr. Sadeq was being kept has been disclosed. And I thought that, I understood that to refer to the entire period of his detention.
It does.
Yeah.
Okay. Yes. So there are no documents relating to any describing his conditions at any point. It's not that, but that I hope my lords understood. That is on the basis of what Mr. Allen has called primary material. Anything describing those conditions has been disclosed.
I thought his definition of primary material was evidence of discussions with Mr. Sadeq.
No,
I didn't understand the evidence to be that what had been disclosed was any document which cast any light on the conditions in which he was being held. But if I misunderstood that,
I respect my lord, and I need to show you that.
Do please.
I was coming to it later, but I think I better go to it. As it happens, I've opened the right page in my note, and if you go to Allen 9, paragraph 123, tab 7, page 106.
So sorry, I opened the wrong bundle. So you said page 127. Which paragraph? Which page?
160, my lord.
160, I'm so sorry. Yes.
And it's the last sentence, my lord, this is an extract of paragraph 123 from Allen 3.
Yes, well,
Yes.
I read that as meaning the records conditions at the time that the discussions, records of conditions when discussions were taking place between Dechert and the claimant. And the reason I read it like that is because the rationale for all this is there wouldn't be any confidentiality in it. I don't see how the rationale applies if there were a document, for example, which came from the authorities to Dechert, which said something about the conditions in which he was being held.
Well, my lord, it may be that they've adopted an overly broad approach to primary materials. But my clear understanding is, and Mr. Allen has confirmed behind me, that everything that records the conditions in which Mr. Sadeq was detained has been disclosed on this basis.
On which basis, sorry?
On the basis it is treated as primary material. Now, as I say, it may be that has been generous. On my lord's basis, a suggestion that the rationale, though, as it was understood, was that it's not just discussions with Mr. Sadeq, it's things describing things to which he was privy, as it were. In other words, he was privy to anything, the conditions, he was in those conditions. So if we had anything describing those conditions, we have disclosed it. And so the answer to my lord's question, or Justice Miles's question, is any document describing the conditions at any point, not just around the time of the Dr. Mitchell report, but at any point in the entire piece, have been disclosed. And Mr. Allen is vigorously confirming that behind me. It was a view taken very early on, as he explains. This is Allen 3, is the witness statement by under cover of which he provided the original disclosure exercise. And given the complexity of the disclosure exercise, he thought it proper to put on the record exactly the approach that had been taken. And that was the approach. And that is why there are these documents, sometimes not part of, as it were, discussions with Mr. Sadeq, but as it were, internal notes of Dechert's, which are being, at least in part, unredacted to show the bit that describes the conditions. And the shackles is a good example of that. That is an internal Dechert note. It's not, as it were, a record of an interview or a discussion. It is an internal note of Dechert's. That bit has been disclosed on this basis. Now, as I say, it may be said that we've been overly generous on that, and there would have been a rationale for, but that's not the view that we thought was the right one to take, and those have all been provided.
Thank you for that clarification.
My lord, whatever the conditions of Al-Bararat, we say that tells you nothing about the other three locations at which Mr. Sadeq was detained, and we say there is no sufficient basis to conclude that the conditions in which he was detained at those places were themselves iniquitous. Finally, reliance is placed upon the further evidence and the references in particular, or the fact that they are said to show hacking, and some references to allegations of human rights abuses. We say that material adds nothing for the reasons we give in our further evidence skeleton at paragraph 32, which is at page 615 of the further evidence bundle, and also in our supplementary skeleton at paragraph 5, which is at page 633 to 634. But in short, Evidence of hacking, we say, does not begin to support a case.
So just give me those paragraph references again.
Yes, my lord.
The supplementary skeleton.
Supplementary skeleton is paragraph 5,
Thank you.
which is at pages 633 to 634.
Thank you. Sorry, you were
The
about
short
to
point
say.
is that evidence of hacking does not begin to support a case. We say that the conditions in which Mr. Al-Sadeq was detained were as he alleges. There is no equivalence. The third iniquity that is relied upon is the alleged denial of access to a lawyer, and my learned friends set out the arguments relied upon, the points relied upon in their skeleton argument at paragraphs 34.1 and 34.2. Can I just, before I address those, make the following point. The evidence clearly establishes that Mr. Al-Sadeq was in fact represented by a lawyer, a Mr. Shamsi, from at least April 2015 at multiple hearings. And you can see that set out in Mr. Allen's ninth witness statement at paragraph 80, which is at pages 143 to 4 of the supplementary bundle. And the first document to which he refers to, showing that representation by Mr. Al-Shamsi, is dated the 13th of April 2015, and for your note, that is in the supplementary bundle at page 369. And none of the matters set out in paragraph 34 of my learned friend's skeleton argument relate to that post-April period. So for that point, for that period, post-April 2015, the denial of access to representation is plainly unsustainable. As for the period prior to that, the first thing that Mr. Sadeq relies upon is, again, his own allegations about being denied access to a lawyer. This is an area where, although those allegations are not admitted rather than denied, because we don't know whether he was denied, we do plead a positive case as to our understanding of what the actual position was, based upon discussions we had with Mr. Al-Sadeq. And can I just show you that in the defence, paragraph, in the defence which is in the supplementary bundle, at page 254, this deals with the first meeting with Mr. Gerard. You can see from the heading at the top of the page, and if you look at 54.3, Mr. Gerard asked the claimant if he wanted a lawyer, but the claimant responded that he was a lawyer himself and did not want separate representation. And if you then go on to page 257, dealing with a meeting with Mrs. Al-Sadeq, at 63.3, Miss Black also recollects that during the course of the meeting, Mr. Gerard recommended to Mrs. Al-Sadeq that a lawyer be instructed on behalf of the claimant, saying that against him, the allegations against him were serious. And then if you go to page 261, at 108.4, it's denied that the claimant was refused a legal representative during meetings with Mr. Gerard or Mr. Hughes. The claimant could have had a lawyer present if he had wished, but he never asked for one. On the contrary, as indicated above, Mr. Gerard had previously asked the claimant if he wanted a lawyer present, and he had said no. Subsequently, on various occasions from October 2015, the defendant specifically notified the claimant's lawyers that that's in the later period. So that's the period post-April, so that's a different point. But the earlier bit in that paragraph is a description of what had happened. And your note, that is also consistent or confirmed by Mr. Allen in his ninth witness statement at paragraphs 79.1 and 79.2, page 142. And Mr. Allen there refers to a briefing note of Bell-Pottinger briefing note from March 2015, which refers to the fact that Mr. Sadeq had not requested a lawyer, possibly because he was himself a trained lawyer. And if that is right, there was no denial of access. It was just that Mr. Sadeq preferred to represent himself. As for the documents relied upon by my learned friends in their skeleton argument at paragraph 34.2, on page 44 of the bundle, the first point Ms. Black's note of 17th September, we say that is consistent, not inconsistent with the evidence. Mr. Gerard, as we say, had told Mr. Al-Sadeq to appoint a lawyer. The suggestion is that the lawyer was not permitted by the authorities, but we don't accept that. If the position is, as we understood it to be, that Mr. Al-Sadeq did not want a lawyer, in other words, did not want to pay for a lawyer because he could do it himself, that would be entirely consistent with that.
Not on the face of it, was not permitted, that wouldn't be consistent with not permitted to see me, or am I missing something?
Well, it may be that Mr. Sadeq did not permit the lawyer to come to see him because he did not want to pay for a lawyer. He thought he could do it himself.
I find that hard. It's only a few words we're construing. That's not a natural reading, I would have thought. Anyway, but that's.
You have to see that note, my lord, in the light of what I've just shown you about Miss Black's understanding and recollection of the discussion that actually took place at the relevant meetings. That is what I've just shown you. You have to read those together, and read together, we do say that it is consistent. I understand and see why, out of context, if you didn't have anything else, if you didn't have what I've just shown you about what Mr. Gerard and Ms. Black say actually happened, how one could read it that way. But there is a real danger of trying to construe a couple of words in this way out of context. With the context that you have, we say it is otherwise. And the other two, next two, little 2 and little 3, are, we say, also consistent with our understanding of what Mr. Sadeq said to Dechert about what he wanted. None of that is about a denial of representation. It is simply he doesn't have a lawyer, and the fact that he only made a single call tells you nothing about whether there was a denial of representation. Just for your note, the third email, the third item there, the date I think for that is wrong. I think that should in fact be the 25th of January 2015.
That's for the one the date at the bottom.
That's the 30th of September.
Item 3, which is 30th of September. I think that should in fact be the 25th of January 2015. The reason I want to clarify that is 30th September is obviously after my April date. It's a misreference, and if you want to look it up, it's Mr. Seattle's 6-witness statement, paragraph 92.5, where at page 57, where he refers to this and gives the right date. And then the fourth document, again, we don't suggest, except that this shows in any way that Mr. Sadeq had been wanting legal representation earlier. The document itself is at tab 28, page 36, 368. Of the supplementary bundle. And it's important that you have the date of that clear. It's at the top of the page. It's the 4th of April. That's important because that was shortly before the first criminal hearing in the proceedings against Mr. Sadeq in relation to what's called the leases case. And under RAC law, a party will ordinarily be given a lawyer appointed by the state at that point, if he does not already have one. That's explained by Mr. Allen in his 9th statement at paragraph 79, paragraph 3, page 142 to 3 of the bundle.
Sorry, just give me the paragraph reference again.
Yes, Allen 9 at paragraph 79, subparagraph 3. He does not say, Mr. Sadeq, in this letter that he has been denied a lawyer. He says he has made a request and he hasn't yet received a response. But we know, from what I said at the beginning, that a matter of days later, Mr. Al-Shamsi was in fact appearing on his behalf, and so the lawyer was in fact instructed. And what Mr. Sadeq does not say in that letter is, I've been wanting a lawyer all along, and that I have been denied access to one. The possibility that this was driven, at least in part, by the prior position before the state appointed a lawyer on his behalf was driven by financial considerations is addressed by Mr. Allen at paragraph 79.4 of his 9th witness statement, where he refers to this letter, but also a prior letter referring to the absence.
So sorry, I'm slow in my note taking. What paragraph again?
Allen 9, I'll just show it to you, my lord. It's page 143 of this bundle. It's at the top of the page, subparagraph 4. Page 143 at subparagraph 4 at the top of the page. Now, my lord, that refers to the letter we just looked at as the 4th of April, but it refers to a prior letter, which I'm afraid isn't.
So sorry, I just want to look at the 4th of April letter again.
I think that is an inference drawn from that letter that.
So I didn't see anything in it
there
about
isn't a
money.
reference to financial considerations. It's an inference drawn on the basis that he's now requesting it at the point where the state would provide it to him. And as Mr. Allen refers to a prior letter, 28th of January, which I'm afraid isn't in the bundle, referring to financial constraints.
And remind me, was Mr. Dr. Al-Shamsi in fact a state-provided lawyer, or was it one whom?
We need to check. We think in the event he may have been chosen by Mr. Al-Sadeq, instructed by Mr. Al-Sadeq, rather than provided by the state. We're not, on our part, we're not sure.
A bit of muttering. You're not in a position to tell us straight away, Mr. Oppenheimer, with the reference. No, we can come back to it.
Finally, the Bell Pottinger, back in the skeleton argument at 34.2, at the end of it, the last point is the Bell Pottinger briefing note relied upon. My lord, again, we don't accept that is evidence that he had been denied access to a lawyer that he wanted to appoint. In the context of all that I've shown you, we say is a perfectly, and particularly the Bell Pottinger briefing note that I also referred to, is a perfectly fair reading of that but it is simply talking about the absence of a lawyer being provided by the state. We accept he was not consulting with a lawyer prior to April 2015, but we say that was for the reasons we give. He didn't want to pay for one because he was a lawyer himself and was happy prior to proceedings commencing to represent himself. And
is that a fair reading of the document at 367? This supplementary bundle 2, 27, page 367. If I've understood correctly, is the document we're talking about.
yes,
And as against NG, Mr. Gerard saying, no access to legal advice and not charged. Not here to talk about rights and wrongs of the legal system. It rather sounds as though the first line is recording what was being complained about.
but my lord, again, there is a danger of taking these things out of the context I've just described. And given all of that, it is equally consistent with an observation that Ras Al Khaimah does not provide a state lawyer to those even who don't have the means to pay for it, prior to the legal proceedings themselves actually starting, the court proceedings start. It doesn't have a legal aid system that covers one from the beginning and all the way through. And we say that that is an entirely coherent reading of that. Some may think that all systems should have legal aid systems, legal aid available, but not all do. And that may be a right or it may be a wrong, but it's certainly a difference between the systems.
Is that Mr. Gerard speaking in the box above?
Page 366.
We've only got a single page. So.
I don't know. My lord.
Yeah, if it comes immediately after reference to by Mr. Gerard to it being a brutal legal system, I would like to explain why there might be some noise going on, two people being arrested. That's the context. Anyway, never mind.
So, my lord, for those reasons, we say there isn't sufficient evidence to deny of access to a lawyer in the period prior to April 2015, when it's clear he did have a lawyer, as distinct from the fact, which is common ground, that he did not consult with a lawyer during that period, which we say was because he did not want, despite being given the chance, he did not want to do that.
We have obviously some documents relating to access to a lawyer, which your side has disclosed. Is that happenstance as distinct from Mr. Allen and his team taking the view that documents relating to access to a lawyer ought to be disclosed, in the same way as you told us the view had been taken about conditions in prison?
If my lord's referring to that, I will be corrected if I'm wrong, but my understanding, for example, for that's been disclosed, and it meets a point that's made on the other side. That's been disclosed because it was a consultation with Bell Pottinger, therefore part of a PR exercise, and that part we accept is not part of the relevant legal role.
So in relation to this alleged iniquity, that's to say access to a lawyer, you're not making the same point that you made to us in relation to conditions in prison, that everything's been disclosed anyway.
That is correct.
Thank you.
They're not, yes. Yeah. My lords, can I then move to in furtherance of? I don't mean to cause consternation by that shorthand. I accept it begs a number of questions, but if I can be forgiven, it is often referred to as that. I'll come to what we all...
Myself, I think it's perfectly okay as a shorthand, provided we accept that it's only a shorthand and has some problems.
The second stage of the challenge requires the appellant to show the relevant standard, which is here a very strong prima facie case, that we have documents which are part of or in furtherance of any iniquity that has been established at the first stage of the relevant standard. And there are probably 4 sub-issues here. The first sub-issue is whether the formulation I have just given is right. And happily, it appears that on that point we are now in violent agreement. Part of or in furtherance of the iniquity properly captures the test. Although I am perfectly happy, my lords, to add in preparation of the iniquity, as suggested by Mr. Justice Goff in the Butler case, though I would respectfully submit it doesn't add much to the in furtherance of the test. Just to answer my lord, the Vice President's question, though, as to where that third limb came from, it is in fact answered by Butler. I'm not going to take you to it, but Butler's at tab 6, and if you look at the bottom of page 129 to top of 130, you'll see the in preparation of came in fact directly from Cox. And it's referred to in Cox, that language of preparation, at page 135 of your bundle, about halfway down, where there's talk about preparatory. So that's the answer to where did that come from, I think. The second sub-issue then is what exactly does that test mean? And we've addressed that in our skeleton argument in section C6, starting at page 83 of the bundle. As you will have seen from that, originally it was argued by the appellant that the test was a very broad one, which included all documents which were created as a result of, generated by, reporting on, or even concerning the relevant iniquity. Again, if I maybe do it this way, give you the references to that. They are in Mr. Seattle's 6th witness statement at paragraph 46, which is on page 30 of the bundle. Paragraph 51 of his statement at page 31 of the bundle. Paragraph 68 at page 44, and paragraph 68.4 at page 45. And that approach was then reflected in the reporting of or generated by language, which was sought in the order and is still sought. And Mr. Justice Murray held that they were wrong to contend that the test was as wide as that, and at least overtly, that is no longer the case being advanced. It is still, however, said that an order in those terms generated by or reporting on is apposite on the facts of this case, but we don't understand, at least overtly, my learned friend still to be pursuing the case that was put by Mr. Seattle in his witness statement and was the basis upon which the challenge was originally brought. But it is clear that there are some differences between my learned friend and I on some of the points, and I just want to see if I can capture those by reference to her, the appellant's skeleton argument, if I may. First, we quite accept that a document can fulfill the test, even though it was not the intention of its author that it further will be part of the iniquitous purpose. And that's the innocent solicitor point, exemplified by ex parte Francis, which has been emphasized by the appellant. That is the approach that Ennio took. They looked at not only the purpose of the author, if it was Dechert, but also the purpose of the client, as Mr. Allen explains at paragraph 128 of his 9th witness statement. But, my lords, it must be someone's purpose that the communication is preparatory to, part of, or in furtherance of the iniquity. Or put differently, the solicitor must have been instructed, engaged for that purpose, even if he is entirely innocent, and indeed, in an extreme case like ex parte Francis, even if the instructing party is entirely innocent. It must be someone's purpose that the solicitor is doing something which is preparatory to, part of, or furthers the iniquity. And that's an important point which the appellant's case tends to lose sight of. Second, we agree with what is said by my learned friends at paragraph 38 of their skeleton argument, which is at page 47 of the bundle. In particular, we agree, although it wasn't said by Stephen, Jay was citing somebody else, with a degree of connection.
So sorry, which paragraph?
Paragraph 38 on page 47. And it's the reference to still affects the accomplishment of it. That is important. Third, and turning to paragraph 40, while we obviously don't dissent from what Lord Sumner said in O'Rourke, which is quoted in paragraph 40, the context in which the underlined words there, underlined by my learned friends, in the course of, the context in which that was said is important. And if I can just remind you of that context very briefly, it's in the authorities bundle at tab 4, at page 88.
Just give me a moment to
I will be coming back to the skeleton
rationalise my desk.
And it's the language, page 88, halfway down the page. The context in which those words are used in the course of or in furtherance of a fraud to which both solicitor and client are parties. In other words, it was he used those words where they were both involved in the fraud, and one can understand why in the course of is apposite language in that context.
Hang on one second.
Yes, it's halfway down, my lord. There's a one.
No, I found it. Yes. To make a note against it. Yeah.
And what we say Lord Sumner was capturing here in the particular facts of that case is a part of test. It's no different to that. It's not intended to be a widening of it. It's not intended to open up is it just happen in the context of on the facts or in the way he put it, we say it is clearly a part of is what he had in mind there. So you do need to be a little bit careful about the underlining taken out of context. Obviously, my learned friends have probably quoted the full part, but you just need to see the context in which those words were used and not to transpose them to, as it were, a freestanding test that is different to or wider than part of or in furtherance of. Fourth, we accept, of course, what Lord Justice Parker said in the Bank Kaiser Allman case, quoted at paragraph 41 of the skeleton argument. But again, you need to be just a little bit careful. Because not only, contrary to the words in brackets, if you look at the sentence in the innocent solicitor case, then it says which was the assumed premise on which Mr. Sadeq's challenge was made. It is, of course, true that it's assumed that we were innocent, but the premise went rather further than that. It was that we weren't involved at all in the iniquities. But further, and this is on the law, there is a hint in this paragraph in the last sentence that there is just a but-for question. In other words, it is sufficient to satisfy the agreed test merely that the document would not exist but for the iniquity. And if that is what is being suggested, it is essentially a reversion to the case advanced below in writing, and is obviously much too wide and inconsistent with the authorities, and including what is said about the accomplishment of it at paragraph 38. A widening of that sort is not supported by Bank, Kaiser, Ullman, or any other case. And if it was a but-for test, it would capture, for example, wrongly capture, an advice from a solicitor in relation to a crime that his client was accused of committing. But for the crime, the advice would not exist. It does not follow that because there has been a crime, a communication that would only exist because of the crime is subject to the iniquity exception. It needs to be part of it or in furtherance of. The fifth point is we gratefully adopt, as you would expect, what my Lord Justice Popplewell said in the Ablyazov case about the approach and the touchstone in this area. And that's quoted by my learned friends at paragraph 42 of the Skeleton argument. The touchstone is whether it is outside the normal scope of such professional engagement or renders it an abuse of the relationship which properly falls within the ordinary course of such an engagement. And that is a very important touchstone which we ask you to keep coming back to, and I will keep coming back to when we look at what is said to be the documents in furtherance of. When you step back and ask yourself, in relation to those, what is the reason why the communications, what is the base upon which it said that the communications are to the relevant standard part of an abusive relationship between the solicitor and the client? We say there is none. And we say that in a way, the contrary argument is made almost impossible on the premise of this application, which is that Dechert had no involvement in the iniquity. Because in all the cases where the iniquity exception has applied, the solicitor has been involved in the iniquity because of the communications have been part of and furtherance of. It has, the relationship has been abusive. It may have been innocent, it may not have known that, but it has fundamentally been involved in the iniquity. The premise of this chapter...
I'm not quite clear what the distinction is you're drawing here. How would the Ablyazov touchstone apply to a case like Francis?
That the relationship was abusive between the client instructing the solicitor because it was for the purpose of secreting away the proceeds of the bank robbery. It was the solicitor or a cousin who happened to instruct the solicitor, and she was innocent of it. But the purpose of the bank robber who had given the money to the cousin solicitor, sister, I forget which, was iniquitous, and the relationship was therefore fundamentally purpose. The solicitor was intimately bound up in the furthering of the iniquity, the secreting away, the hiding, the handling of the proceeds of the crime. They were absolutely involved. That's the problem. They didn't know that. They thought they were doing something perfectly normal, but the relationship is an abuse because the solicitor has essentially been dragged in.
So suppose, and you, I know from what you said yesterday, wouldn't have said this was within the scope of the iniquities relied on for this application. But suppose there were evidence of the requisite strength that Decherts had been instructed without knowledge on their part to question Mr. Sadeq in pursuance of an iniquitous scheme under which he would be put under pressure to provide evidence against Dr. Al-Massad. That would be an abuse of the relationship on the assumption that engaging solicitors to carry out investigations is itself a normal professional relationship. But you say that isn't the case here because that is not the iniquity complained of.
Yes.
And on the basis of the three iniquities complained of, Decherts were really not involved in furthering that purpose at all.
Exactly so. And as I say, the premise of the challenge is that they were not involved.
Well, I've got that. Yes, thank you.
That's why, I'm sorry, my lord. That is why my learned friends have sought to change the iniquity. They have sought to turn it into something it has never been and is inconsistent with the premise, because they want to move towards my lord the Vice President's approach, which is to say, actually the entire questioning process was the iniquity. They want to say that you buy aluminium.
Well, part of the iniquity, that's enough.
But fundamental to it. I mean, it's of course, there's something that it's an unlawful gathering exercise, is what is being said.
The point is that all of the iniquities, keeping Mr. Al-Sadeq in inhumane conditions, if that's what happened, were not objects in themselves, but means to getting a confession or other evidence out of it.
My lord assumes
No, I would say that's the point that you're saying they want to make.
Yes, exactly. And we say there is
So
no
that's-
basis for that assumption. There's no evidential basis for supposing that that was the entire scheme. This was a man.
Well, hang on.
Well, yes.
Sorry.
I know we're about to make this. I'll make mine first. Yes. I got in 30 seconds earlier. It's not so much there's no evidence of that. It's that those are not the iniquities relied on.
It's both.
Well, all right, but
Well, I was cavilling at the first because that is clearly what's pleaded with a statement of truth.
My lord,
That isn't it?
I'm not sure, my lord. That the purpose of that was to the purpose was of the detention was the extraction of information. I need to look at.
would that matter anyway?
You need to look at paragraphs
if-
11 and 19, but that was my impression.
Yes, we should look at those
My lord,
paragraphs.
they're
But
more
would it, if it was, it might have to be put quite high, but if it was the inevitable inference, but there was no primary evidence, that would still be a basis for proving the iniquity, wouldn't it? So there's no evidence of that, but the evidence consists of an inference from other facts, of which there is evidence.
My lord, if the appellant is allowed to change the entire basis of the application, and if my lords was to conclude that the inevitable inference from the iniquities which my lords have on this hypothesis concluded existed, is that that was all done as part of an overall scheme,
Yeah.
in which my clients were innocent on this hypothesis participants, I can see it becomes harder.
Yes, well, that's very fair of you, but also realistic of you. Right, well, let's just pause there, but let's just look at the passages to which my lord referred to see actually how far the evidence does go.
I think what I had in mind was paragraphs 9 and 10. Supplementary 1, tab 11, 205. which is the summary of the case. It starts with kidnapping, rendition, unlawful detention, and so on and so forth.
Could I also draw attention to paragraph 33 and 29?
Yes. Well, I was going to go to 10, which summarised the effect of all those things as being as it being done in an attempt to build a case against Massad and his co-conspirators at the behest of the ruler of Rat.
My lord, point. Even allowing for the fact that he has a statement of truth, that can only be Mr. Sadeq's belief as to what was going on. That is not evidence of fact, even in terms of a statement of truth. He cannot give evidence about what the purpose
No,
is.
but to say it's unevidenced, it's the case, and it's based on statements as to what the evidence is, including in the immediately following section, what one might call the reasons for a vendetta against Dr. Massad, perhaps slightly too summarily, and then the conduct in question and the inferences that are to be drawn from particular aspects. That's what's being done is at the instigation of the ruler, and so on.
Well, my lord, that's the way.
I mean, I do understand your point that that paragraph 10 is conclusory, as it were, as opposed to a primary evidence, but it's a conclusion drawn on the basis of the primary fact assertions.
And those are assertions which
Assertions
are
only.
and denied.
Yes.
You understand that our case is very clearly that we were instructed in the context of a massive fraud that had been perpetrated on the
I
state.
entirely understand that. All I was seeking to do was just to draw a distinction, perhaps, between the two different aspects of the point you're making. One focusing on the particular iniquities that are relied on for the purpose of this application. Nothing I'm saying is intended to affect that.
And the other is the evidential.
The other was the evidential point. That was all.
My lord has what I said yesterday about the evidential point. I made the submission and I don't. Whatever there is not enough. It's a big leap with respect, my lords.
It's what, sorry?
It would be a big leap to conclude on the basis of this material to the relevant standard in this case, a very strong prima facie case, that those allegations, the belief of Mr. Sadeq as to why this happened, was, as he alleges, as opposed to that he committed the crimes of which he's been convicted and was incarcerated in Ras Al Khaimah as a result, in the course of which he was asked questions in order to find the other wrongdoers and have evidence against them. That is the leap that you are being asked to make. My lord,
I'm not sure it is a leap if, and obviously it's a huge if, what he asserts about the iniquities to which he was subjected are made out.
Well,
and the two are not wholly unrelated.
my lord,
I'm not sure.
I've made the point that I've made that we don't accept that. It's difficult to put in a as it were, way that doesn't sound like I'm trivializing the allegations.
No.
But there are places in the world that may not be places one would like to be detained for stealing from the state. If the assumption is that Ras Al Khaimah is one of those, it does not follow that the reason why it's that sort of state where you would not wish to be incarcerated for stealing from the state is to extract information from people. It just is, on those facts, a place you do not want to steal from the state and find yourself caught. My lord, coming back to Ablyazov, the other important point to note about that case is that although my lord found that Mr. Ablyazov was bent on his iniquitous strategy from the moment he instructed Claimant Co, and that their advice was sought from the very start in order to assist in fashioning and pursuing that iniquitous strategy, and that's paragraph 98. Nonetheless, not all communications in the course of that relationship were caught, only those that furthered that strategy. And one finds that at paragraph 102. And with respect to my lord, who obviously knows the judgment better than we do, we don't, on the face of it, accept, if this is what was suggested yesterday, that my lord decided that in principle, in furtherance of the iniquity, always includes documents revealing the iniquity. On the particular facts of that case, all the accounting documents were part of the iniquity. And that's what my lord found at paragraphs 102 to 104. And it was that made them disclosable. So in the facts of that case, everything that revealed it was part of the iniquity. Because the argument was, does perfectly truthful documents, are they part of it or not? And the answer was they are, because you're presenting half the information and it's misleading to everyone.
But I think on your case, my order went too far. Because it was essentially...
Not on my lord's findings, but the entire relationship from the off was in order to advance an iniquitous purpose. And then, as my lord did, to carve out any bits that didn't.
Can we just test that? Suppose you had taken a different view, Mr. Allen had taken a different view about whether documents revealing that Dr. Al-Sadeq was in shackles were primarily disclosable because they weren't confidential in the first place. Would they, on the test that you're advancing, have been disclosable at all?
My lord, I'm so sorry, could you repeat that?
Yes, really. It became clear from earlier this morning that Mr. Allen took the view that documents that showed that Dr. Al-Sadeq was in shackles, and I take that as an example of documents relating to the conditions generally, were disclosable, were primarily disclosable. I think that's his phrase, or the phrase from your side, meaning they're disclosable because they're not confidential, so no question of privilege or then whether iniquity even arises. And you conceded that arguably that was a rather generous view because it's not like communications which happened with him. In any event.
I wouldn't use a concession, my lord. I just, given your lordship's question.
All right, I didn't mean concede. You observed. But just suppose he'd taken a different view about that, and he was right to take a different view about that, that the conditions in which he was held were documents which revealed the conditions in which he was held were confidential. Right? So, therefore, the documents relating to him being in shackles were confidential. Are you with me so far? On the test you're now advancing, would those documents have been disclosable because of the iniquity exception?
No, my lord.
I think that's right. I just wanted to test it.
Then they would not be part of or in furtherance of the iniquity.
And how do you square that with the passages in the authorities that we've seen about cases in which, where there is iniquity, the lawyer's lips cannot be closed up, and the public interest is one that it should be revealed?
My lord, we say that is a rationale for the iniquity exception in the terms in which it is couched, in furtherance of or part of. It does not mean that anything and everything that happens once there is an iniquity is revealed.
But is it not a rationale which suggests that what is to be is that which reveals the iniquity?
My lord, that would go too wide on everybody's understanding of the law. On that basis, and contrary to what my lord held in Appellant, or what the authorities have previously held, an advice, an otherwise privileged advice in which the advice was sought from the client having committed a crime from his solicitor about the case could be open for disclosure. There has been an iniquity that contains relevant information. It may reveal the iniquity. Derby and Weldon is the Derby magistrate's case is the most extreme example, where the relevant evidence might have been critical to the defence to a charge of murder, but the opening up anything that reveals the iniquity or answers it or meets it is not the test. It is in furtherance of or part of, and I understand my lord's point, which is that the test may be informed by the thinking behind it, but it is not the case on the authorities, we say, that anything that mentions something inequitable in the course of a non-abusive relationship is caught by the iniquity exception.
Quite in a non-abusive relationship. But are you applying the question as to whether it's an abusive relationship on a document-by-document basis? Or are you, as I think I thought in Appellant, starting with trying to draw the line between the ordinary run of cases where there's no room for the iniquity exception to apply, advising a defendant on his defence in criminal proceedings, take the classic example, and cases where there is an abusive relationship. And if you're not in the second category, there isn't any room for the iniquity exception to apply. But if you are in the second category, why is the scope of the exception not one which captures having to reveal the iniquity?
If my lord's second category was one in which the relationship is abusive, did I understand that the first category is overall relationship abusive?
No,
non-abusive.
The first category is non-abusive. You simply don't get into iniquity at
all.
And that's what Appellant was trying to draw. No.
It has not been hitherto part of the iniquity challenge that the entire relationship was abusive, and that everything, otherwise, my lords, we wouldn't have focused on specific iniquities. And you can see from the way it's been done, as we'll come to in due course, the approach has been done on there are documents within the relationship, as opposed to any suggestion, at least overtly, that this is a iniquitous relation. This is an abusive relation. We were retained. No, whatever else I think is said in this case, it is not suggested that at least a significant part of it was to investigate a fraud. Now they say there were motives behind that. I understand that, but there was there were multiple cases across the world prosecuting these frauds, and I had not understood, and one contested in a sense by the LAP challenge. It is not said in that context that this entire relationship just comes down. And instead, the approach has been so far, that certain categories of document within the relationship further the iniquity. And as I'll show you, that's very much, here are 3 categories of document which we say would be within it, rather than say that the whole house comes crumbling down. And indeed, my lord, I'm sorry to come back to it, but not only has it not been said, it is fundamentally inconsistent with the premise of the application, which is that we were not involved in the iniquity. In Abli-Azov, the solicitors were fundamentally involved in the iniquity. They didn't know it, but they were. It is
isn't that the premise on which they're saying this application should be decided? Innocent tool.
But an innocent tool is involved in the iniquity, innocently.
Well, so is the recipient of the lawyer as the recipient of a putative document in which the ruler describes the conditions in which Mr. Al-Sadeq is being held?
My lord, the simple fact that there is a communication which refers to conditions does not bring into play the iniquity.
I know, and I'm just trying to explore. I absolutely understand that's your point, and I'm trying to explore whether you're right about that by reference to the rationale for the iniquity exception in cases where the solicitor is being used as an innocent tool. The solicitor is involved in those cases. Otherwise, we wouldn't have the document we were talking about. But
What does involved mean? Does it mean assisting in the perpetration of the iniquity, or does it mean
The thing
something
they are
else?
doing is part of or in furtherance of the iniquity.
Well, furtherance of we can understand. That clearly means doing things which help the iniquity to occur or be continued. Part of what you would say the same, effectively. It's just
What I would say it's not, I'm trying to come up with an example. Assume.
Well,
Yes, sorry.
the instance I debated with you earlier is, I think, quite a good example where the solicitor is told something, and let's assume the facts are starker than you say they are, that make it clear that Mr. Al-Sadeq is being held, Dr. Al-Sadeq is being held in conditions which are contrary to human rights. You're saying, well, you may have been told that in the course of the relationship, but you did nothing to further that or to continue that, and so it's not caught. Isn't that quite a good example? If it's not, suggest a better one.
No, and that is a good example, and we say that's not caught.
I know.
There is
because
no,
you say that's no different from the situation in which the solicitor is told that about what the position was in relation to some iniquity before they were instructed. It's just the same position, unless they are being abused.
yes.
The relationship's being abused in some way in order to further the iniquity in that respect.
Yes.
Then.
Assume that in a con, a client comes to see you to discuss something totally normal, unexceptional, and in the course of that privileged meeting, they refer to something that they did. The iniquity exception could not be invoked to say that the conversation no longer was privileged, simply because it referred to that fact. The relationship would not be in any way abusive. The reference to the fact would not, any conversation that did or did not take place about it, would not further it. It would not be part of it. It would not affect the accomplishment of it. It would be simply a reference to an iniquity, which would evidence it. And no doubt someone would like to see it.
Would it make a difference if the duty was, if the communication was one which they would otherwise be under a legal obligation to disclose, so that the concealment or the non-disclosure furthered the accomplishment of the iniquitous purpose? I'm sorry.
I'm finding it difficult in the lawyer relation. I mean, there may. I'm afraid it's beyond my limited knowledge.
No,
my lord may know better, but it's not obvious to me what there may be examples of things. I mean, okay, AML, money laundering. There are obligations on a lawyer to disclose, I suppose. But I'm just trying to think what it is exactly that the example you have in mind.
No, well, It's a fair point, but I'm not sure myself. I was leaping off from the fact that in Ablyazov, my lord made the point that telling part of the truth is itself helps to accomplish the purpose. So this problem didn't arise.
One can see that if there was a scenario coming out of my facts. But I find it difficult, actually, my lord, to see how it could work.
Leave it for the moment. Leave it for the moment.
It's probably my fault, but I'm finding it difficult to see if there was the iniquity of a big cover-up. I'm finding it too hypothetical, my lord.
No, well, fair enough. If I'm still worried about it by the end of your submissions, I'll ask you some more. I've noticed from time to time, all advocates do this, you've glanced at the clock, and we have slowed you down.
I'm sorry, that
No.
I don't intend to be rude at all.
No, of course it wasn't. No, I didn't. But all I meant was just a polite way of saying, I know you're probably a bit concerned about time because we've slowed you down a lot on this crucial point. I dare say you want to move on from it.
If convenient to my lords, I have plenty still to get through. This all jumped off from our consideration of, or you're referring us to Ablyazov, or to more accurately to how the appellants were relying on Ablyazov. Yes, and my point about the touchstone and the importance of coming back to it. I think the discussion has highlighted, I hope explained what we say about that, and in a sense, the discussion we've had may shorten looking at the particular categories, because my answer is going to be generally the same, and the debate may just keep on going in a similar vein, and I won't be able to help you much more. I'll take a few examples just to show you some of the points, but I may have to try to shorten that. The third sub-issue, that's all I want to say at the test at the moment. I was going to come to its application to facts in due course, but as I say, I've just been hammering that for a few minutes.
Well, I'm sorry to slow down, but I'm interested to know just what your submission is on what part of adds to in furtherance of.
As we say in the skeleton argument, my lord, it is difficult to see that something that furthers it won't also be part of it. I'm not finished. What does it add to in furtherance of? As we say in the skeleton argument, it is really dealing with a document that is a communication that is iniquitous in itself. That is what we say, that's where it comes from. It is itself. So, for example, a sham document, or the document that is itself the lie, it is the very part of it, as opposed to things which affect the accomplishment of the iniquity, which is the in furtherance of. That's the distinction we say that is being drawn. In other words, in furtherance of is there to clarify that it is not enough. The test does not catch only those things which are in themselves, as it were, iniquitous, or actually are the very doing of the iniquitous thing. It captures those things which affect its accomplishment. And that is the distinction that's drawn in the passage which Stephen Jay referred to. I think that if the communication has not for its immediate object the carrying out of the fraud, that is part of the fraud, but still affects the accomplishment of it, that's in furtherance of.
So in fact,
and my lord, I'm reminded rightly by Mr. Pearce that in our skeleton argument 36 we refer to what Stephen Jay said in Coxton and Railton, and this is the point I was grappling at. Communications privileged in themselves, criminal in themselves, or intended to further a criminal purpose. That is what the part of or in furtherance of test has always is trying
In
to
fact,
capture.
another problem with the in furtherance of shorthand is actually we're focusing on on the less important part of the key concept is part of, and in furtherance of is simply to make clear that that includes not only something that's iniquitous in itself, but something which furthers an iniquity.
It's the dichotomy that, exactly, my lord, it's the dichotomy that you see throughout the cases, referring to things that are themselves iniquitous, or criminal in itself, and in furtherance of, or in the passage here, the communication has not for its immediate object, carrying out the fraud, that would be part of, but still affects the accomplishment of it. The still affects the accomplishment of it comes from a paragraph my lord asked about and what it meant. In that case, the accomplishment of it was the language was being used earlier in the same paragraph to refer to the cajoling of the solicitor to get on with what was happening, what was being done, and encouraging him to do it well and discreetly. But the thing that was being done was unbeknownst to the solicitor, part of a great big scam. And that is, in furtherance of, is intended to make sure that you don't lose those. Part of is not intended to capture anything that happens in the course that refers to the iniquity. And that's why I said, in course of, in the language of Lord Sumner, you need to be careful with it. It is intended to be part of in the relevant sense. My lords, the third sub-issue is whether Ennio applied the agreed test. There was a frankly arid debate about whether the Barrowfend formula is the right formula or not. It was originally accepted that it was the right formula below. You'll see that in Mr. Seattle's 6-witness statement at paragraph 47. It was subsequently said that it was the wrong test. Never found it entirely easy to understand what exactly the objection to it was. But in any event, Mr. Allen has clarified what we said on instructions in our skeleton argument for this court, that the test he applied was part of or in furtherance of the iniquity. That's his 17th witness statement at paragraph 8. And that's the further evidence bundle at page 651. So that was the test applied, and for good measure, Ennio have reapplied it in the light of the further evidence. And as you know, subject to 8 words, nothing has changed as a result of that exercise. But we say that what the unredaction shows is Ennio applying the iniquity exception conscientiously, and it's certainly not, as was suggested by my learned friends, I think as long ago as Monday, that it shows itself cause for concern, because they say, well, there must be other things in the same letter, on the same daybook, that refer to similar things. My lord, if there were similar things covered by the iniquity exception, they would have been disclosed as part of this exercise. And the simple fact is that there isn't any more of this, as is clear from Mr. Allen's response to the questions about this in the bundle the further evidence bundle for your reference at paragraph 4 of his letter at page 706. My lords, can I then move to the final sub-issue on the further part of the inquiry, which is whether there is a very strong prima facie case that we have documents which are part of or in furtherance of any of the 3 iniquities, insofar as my lords find them established to the very strong prima facie standard. While I'm in light of the time and the discussion we've already had, which covered a number of points, I won't take the whole through every single subparagraph. If I can go to their skeleton argument, the easiest way to do this is by reference to the paragraphs where they say there are, in each case, materials suggesting that documents forming part of the iniquity comprising the unlawful detention of Mr. Sadeq existed, but over which privilege has been claimed. And then they, in each case, it's the same formula. They then give various categories, and then they have a paragraph that says, for example, and that's said to be an example of how we should infer that there are more documents of the relevant sort.
Sorry, which paras are these?
Yes, my lord, it's page 41. The first one is 32.4.
Yep, thank you.
32.5. Then there's a similar formula for each.
Yes.
As quickly as I can, take you through those. So my lords, there are two questions in each case. First, on what basis is it said that there is a strong prima facie case that documents of the relevant sort description exist? And second, if they do, they would be in furtherance of the relevant iniquity, which is in this case the original detention of Mr. Sadeq in Dubai. Or at least that's what 32.4a is dealing with, the original detention. As to the first question, what's the basis of supposing there are other documents on this over which we claim privilege? 32.5 tells you there why it is said that we should suppose that there are other documents. But I do ask you to note that it is obviously speculation, because they say insofar as the part redacted involves those other things, then it should be it would need to be privileged. But the speculation with respect ignores the evidence of Mr. Allen, which he gives in his ninth witness statement, specifically about the unredacted parts of this note. I can just show my lords that very briefly. It's at Allen 9, paragraph 10.2 at page 118. And at 10.2, Mr. Allen specifically addresses this email, or this note, and explains that, having looked at it, there is nothing in it which was in furtherance of the alleged abduction of Mr. Sadeq, or indeed any misconduct. It also ignores, in the same statement, the evidence of Mr. Gerard, given by Mr. Allen, about what Mr. Gerard and Miss Black say, that they did not know about the intention to detain Mr. Sadeq before it happened, and that's paragraph 50 of the same witness statement. I'm not going to ask you to turn it up now. So they say they didn't even know it was going to happen. Mr. Allen has confirmed in relation to that specific note that it doesn't contain things of the sort that they describe. So what basis is it for inferring on that, by reference to that these things exist? Even, my lord, if it was there was good reason to suppose that documents in the category A existed, we would say, and I'm essentially going to be repeating what I've said already, that they would not be caught by the iniquity exception, or they would certainly not necessarily be caught so caught. It would depend upon a finding that the relationship was abusive, and we say that there is no basis for that. In other words, it would only further the iniquity iniquity or be part of it if the purpose of someone, no matter who, for which Dechert was being consulted about these matters, was to further the iniquity, to affect the accomplishment of the illegal detention in Dubai.
And by about these matters, you mean specifically the detention?
Yes, yes, exactly. If that was not the purpose of the communications with Dechert, falling within this category, there are such documents, contrary to the evidence, as I say, that we didn't even know about it, so there's going to be no discussion about an intention to do something we didn't know was going to happen. If that was not the purpose, there's no basis for finding that there was something abusive about the relationship. You need to find, either, as my lord put it earlier, that the entire relationship is abusive, or at least that the specific purpose for which Dechert was being consulted or having the communications on any particular occasion was, I don't mean on any particular occasion, but in a particular context in relation to a matter, if I can put it like that. And there's just no basis for finding that somebody had the purpose when discussing, if they did, these matters between them, that was the purpose. And that somehow Dechert was being made the innocent tool in that iniquitous purpose. B and C seem to relate to the subsequent detention in Ras al-Khaimah, and I've said what I say about whether that was unlawful. But again, even assuming against me that you find it was unlawful, we don't accept that it follows that a conversation, if it occurred, a communication about whether the individual should continue to be detained, furthers or is part of the iniquity. It would be perfectly possible and coherent for Dechert to be instructed to advise the ruler advise the client, but they took instruction from time to time from the ruler. It would be perfectly coherent for them to advise or discuss whether it was appropriate to consider that Mr. Sadeq had provided helpful information, and whether the ruler was in those circumstances willing to pardon Mr. Sadeq without that being abusive in any way.
The hypothesis on which we're testing this argument is that it's the ruler's intention that there should be fulfilled the iniquitous purposes of unlawful rendition, detention in inhumane conditions, and abuses of human rights. Putting it crudely, it's also the case that Mr. Gerard is instructed by the ruler to play a part during the course of this involving asking him questions, for example. Is that not Mr. Gerard being used as an innocent tool to further the ruler's iniquity on those hypotheses?
I think on those hypotheses, I'd like to look at all the transcript.
Yes.
I'm
on the abusive relationship point.
If the purpose, I know, I understand. Yes, sir. On all of those hypotheses,
yes,
it obviously becomes rather harder to say that it wasn't. But
those are the hypotheses. We've been through stage one, sufficient evidence of existence of the iniquity. Stage two of my analysis was it's the ruler's intention that iniquity should occur. Whoever the client is, the ruler, whoever it may be. That's stage two, and that probably follows from stage one.
I don't accept that.
You don't accept that?
I don't accept that. Don't accept that follows at all. if it simply is the case that the prison authorities or whoever's running Al-Barat, the conditions, they put them in conditions that are of the description that Mr. Sadeq says they were. It doesn't at all follow that that was my client's purpose or those from whom they took instructions, including the ruler. That may not have been his purpose.
It's the latter we're looking at. For these purposes.
That may not have been his purpose at all. His purpose may simply have been for these crimes to be investigated, for the relevant people to be detained, and the perpetrators punished in accordance with the law. There is no basis at all to infer. It's an important.
You don't accept my speech, do I? I understand. But if premise 1 and premise 2 is correct, would Dechert not be being used as an innocent tool to carry out further the iniquity?
No, my lord, without building in a further assumption, which is that the purpose of all of this was not only that Mr. Sadeq be subjected to these things, for example, by way of punishment, but that he was subjected to them for the purposes of obtaining information. And since then, I accept that Dechert were the people who were doing the obtaining of the information, it would, on all of those hypotheses, be difficult for me to say that innocently their asking of the questions was not that part of the relationship, that the questioning was not part of something to that extent abusive. But we have, of course, provided, because for other reasons, all the evidence of the discussions that actually took place between Dechert and Mr. Sadeq. And one would need to think very carefully about what beyond that, it's the Ablyazov one, I can see the point that in that context, on all of those premises, none of which we accept, certainly don't accept they're made out to the relevant standard, you would still have to ask, beyond the interviewing process itself, which would, on this hypothesis, be the bit that was they were being used an innocent tool for. Beyond that, what around the edges would be caught? Why would every communication that took place, or even necessarily communications of this sort, be caught?
Well, that may be right, but I think Ms. Oppenheimer would refer to the fact that there are references, and one would anyway expect, Mr. Gerard and Ms. Black reporting back to the ruler or other RAK associates, and that is what you'd expect. They were the clients.
I can see, my lord, that on the hypotheses that we're on, I can see that on that basis, the reports of what had been said would necessarily be caught up in the process. But as I'm reminded, the reports of what were said at the meetings have been disclosed.
Well, yes and no. Unless I misunderstood what has been disclosed, the notes of what has been said at the meeting have been disclosed.
Documents recording what was said at the meeting.
Well, I think they're referred to as minutes, but it doesn't really matter. But it's effective. The notes are.
It's wider, my lord. It's not just the minutes of the meetings. It's other documents that refer to what was said at the meetings.
I see. Those have all been disclosed, have they? So if Mr. Gerard went to see the ruler the next day and said, this is what came out of the interview, and had a discussion perhaps about the implications of what came out of the interview or what to ask next or that sort of thing, and a note was taken of that meeting or a record made of it afterwards, an attendance note effectively, those have all been disclosed,
No.
if they happened.
No. There were a number of different strands to that conversation. Insofar as the conversation and the record of the conversation described the conditions of this example in which Mr. Sadeq was, or described what Mr. Sadeq had said to Dechert, they have been disclosed. Insofar as they deal with, as it were, the subject of other things, for example, advice, they haven't been. Yes, that's the distinction. So, and indeed, commentary from those involved on any description hasn't been disclosed. That's privileged, we say, and it's not within the iniquity exception.
No, I see why you say that. Have we just don't take me to now, but we've got examples of those on that basis, I assume, quite heavily redacted notes of such meetings.
We won't have them in the bundle. We were in danger on size of bundle in any event. Somebody will look behind me to see whether there is a good example of one of those actually in the bundle or not. But that is, I'm reminded that the blindfold email is in the bundle somewhere and may be an example of exactly.
Yes, I see. Thank you. Okay. I don't want to hold you up any further.
No. It's helpful, my lord. It may not be productive. My lords have the points I think that I'm making. I was going to go then to 33.3 and do the same exercise again. But can I just, rather than, you have my submissions on furtherance of, part of. I'm not sure it's going to assist to go through each of these paragraphs given the width of the discussion we've already had. Can I just make a couple of more specific points, though, about what is said at 33.4, which is a paragraph now in the context of conditions. The point being made is you can suppose that there must be other things. See the blindfold example, in fact, has happened. It seems very likely there are other communications between Mr. Joe and Mr. Buchanan about the blindfolding of Mr. Al-Sadeq. You see that?
Yes.
But my lord, again, that entirely ignores the evidence of Mr. Allen specifically addressing this document at Allen 9, tab 7, page 138. At paragraph 72.4, where he says, he refers to this, the blindfold, and then he says in the final sentence, there is no record of this issue resurfacing at a future meeting. And none of the individual defendants recollect Mr. Al-Sadeq being blindfolded after this point in time. So, the assumption is, or that you're being asked to find, that there must have been further discussion about the blindfold. But Mr. Allen has actually addressed that by reference to the documents. He says there is no further record of that having occurred. Just for your note, on the sometimes in Shackle's note, which is in the second half of 33.4, Mr. Allen addresses that in footnote 53 of Allen 9, at page 138, where he explains that this appears to be a reference to the first meeting between Mr. Sadeq and Mr. Gerald at GCHQ, to which Mr. Sadeq was brought in handcuffs. Mr. Gerard asked them to have them removed, and they were. And given that, there's no reason to suppose that there are likely to be further discussions, documents about that matter. There's absolutely, it's no reason at all. and indeed, given that we have disclosed all documents that refer to, and all the relevant parts of the documents that refer to the conditions, including these matters, and given our evidence that we didn't know about the relevant iniquities, the conditions, subject to the Dr. Mitchell point, it's entirely unsurprising that there is no more about this in the document. My Lords, on 33.3a, B and C, the various categories, you have my submissions. We don't, there are a great many premises that would need to be built in before any of these were, we say, within the test of infirmance of part of. A is essentially the point I've already dealt with my Lord Vice President, implications, again, I'm going to make the point again. We disclose the documents that show what they describe the conditions, insofar as we say we didn't know about the conditions. Why are there going to be? There aren't going to be communications reporting concerns about conditions about which we didn't know. And indeed, the entire premise of all this is we didn't know about the iniquities that are alleged. That's the basis upon which this application is put. My Lords, iniquity 3, denial of legal representation at 34.3 and 34.4. Sorry, I should just go back and just on the previous one, dealing with Dr. Mitchell. There's a point being suggested.
So sorry, where are you?
I'm sorry, I should go back.
Back to where?
33.3C.
C. Yep.
The reference to Dr. Mitchell.
Yes.
And what was said yesterday was that the entire instruction of Dr. Mitchell was part of an inequitable purpose. Effectively, it was I think it was described as a whitewashing of the conditions. But that we would say would be an entirely different form of iniquity. In any event, it's not one for which we say there is close to enough evidence. The natural inference of the instruction of Dr. Mitchell is entirely the other way. In other words, that he was instructed because everybody thought, in fact, that the conditions at Al-Barat were okay. Mr. Allen gives evidence that that's certainly what the Dechert understood. That's Allen 9, paragraph 74.3 at page 140. And we say that that inference is supported by the fact, or reinforced by the fact that Dr. Mitchell, when he found what he found, was not asked to produce, as it were, a whitewash report. He just didn't produce a report at all. There was also some reference to a cover-up of all of this. This has been dealt with extensively by Mr. Allen in his evidence, and that's Allen 9, paragraphs 74 to 76, at pages 139 to 141. My Lords, I'm not sure that it's likely I'm going to gain much more by going through each of the examples in relation to the alleged denial of legal representation. We make broadly the same point. Specifically, we say in relation to 34.4, I've already made the points about what we say that note shows and doesn't show. But given our pleaded case that I've shown you about what we knew or what we understood, it's difficult to understand the basis upon which it is said that there are likely to be documents which in fact evidence us knowing that he was being denied legal representation. And again, it's the premise on which all of this is built is that we are unaware of the fact that he has been denied legal representation. On what basis then is it said that there are likely to be documents discussing the implications for the investigation of the absence of legal representation. Communications which evidence the reasons why he was denied legal representation that we have. And my lords, I'll make the point here just as another example. If there was a discussion about the reason for communications which evidence the reasons why Mr. Alstead was denied legal representation, why is that part of the iniquity? Why would advice about legal representation, why is that part of an abusive relationship? Assume that Dechert was asked to advise about whether or not it was necessary for Mr. Alstead to have legal representation. How does that further? Why is the relationship abusive? How does it further, or is it part of the denial of legal representation? I mean, one could construct a hypothesis in which it might be, but the burden is upon Appellant to show the very strong prima facie case that such a communication would be abusive. And there isn't a basis for it. My lords, some points were also made in the further evidence skeleton, supplementary skeleton by my own friends, about how we have taken, which they say suggest that we've taken too narrow a view of the iniquity exception, essentially on the basis that we didn't disclose the further evidence ourselves. And what is said is that we have disclosed a few documents which refer to hacking in our original disclosure, and it said we must have gone wrong. What all of this ignores is the fact that, as originally pleaded, there were no allegations about hacking prior to the commencement of proceedings. And so the exercise we performed on disclosure was not looking, because of reasons of relevance, for anything to do with hacking prior to the commencement of proceedings. That is why we haven't disclosed anything on that topic. It is true that hacking has subsequently, by amendment, been pleaded in relation to the earlier period. But we have not yet provided disclosure in relation to that issue, because the pleading by the claimant is still subject to further amendment, as they've told us, and our response to it has yet to be put in, and we have therefore not done the exercise yet.
So I was on top of this at the time with the case manager at the earlier hearing. There has been a pleading for which permission has been given,
Yes.
which has made allegations of hacking, and in relation to which you have not given disclosure. But the reason you've not done so is that there is a further draft amendment, which...
You haven't even seen it yet.
Right, but you have been told that there will be a further and better pleading on the hacking issue,
Yes.
and you didn't want to do the exercise in 2 bits. Is that right?
Exactly so, my lord. And then we will respond to it, and by reference to the issues as they then appear, we will do the disclosure exercise.
Yes.
In relation to that.
Yes.
To those issues as they will by then. So the fact.
Sorry, yes, that was just me clarifying.
No,
exactly
my lord is entirely right. And although they refer to a couple of documents in paragraph 11.2 of the skeleton argument that I just referred to there, supplementary further evidence, those are documents. I think it's in 11.1. Those are documents that we disclose not because they relate to hacking, but just because they related to the issues as they were in the case as they then appeared when we did the disclosure exercise. So nothing in the further evidence is any cause to be concerned about whether we have gone wrong on our application of the iniquity exception. My lord's a bit later than I hoped. That is all I wanted to say about the iniquity exception. I think it would be helpful if I can to start the next topic, given what I need to get through this afternoon.
Yes, certainly.
I may.
Or, I mean, if you would prefer to regroup and we sit again at 5:2, that's also fine. In your hands. You might want to introduce it. It's up to you.
I'll just tell you what it is. I will be able, I hope, to take it relatively quickly. It's the LIP, the burden of proof in West London type. It's the point that Mr. Allen's evidence isn't enough on the dates. And just as a headline point, we say this is West London pipeline is authority which everybody subsequently has worked on, has been approved by Starbev, approved by the Court of Appeal in WH Holdings and other cases. Unless there is something makes you reasonably certain he's gone wrong on the dates, you don't go behind it. This is an extraordinary case in which there is not a single suggestion made that Mr. Allen has got something wrong, that there is a reason to suppose in the evidence that he has got a date wrong. What is all that is actually said is that his evidence is incomplete because he could have provided more documents to substantiate what he says he has seen in the documents. To which the answer is, as Mr. Allen explains, the documents that he has had to refer to are privileged documents. And he can't, therefore, give more evidence. The statement is not, therefore, incomplete. It is not said to be untrue. It is just said that it doesn't discharge the burden of proof. My Lord, I'll elaborate on those after the adjournment if I need to. But it's a relatively straightforward point, this one, and I'll deal with it if I need to. Still call it 5-2.
We'll still call it 5-2. Life being what it is, that means we will at least start by 1. By 2, that's to say, yes. So 5-2.